Thanks everyone for joining us for this annual case law update from Decon. I'm going to be talking to you about a few of the biggest personal injury cases of the last year. I didn't do this on purpose, but they all feature members of Chambers, including Ella, who's too modest to talk about her own case. Ella is then going to talk to you about clinical negligence cases, three big cases in that area in the last 12 months. And finally, Tom's going to finish us off by talking about five important cases in the area of travel law. Um, so I'll just jump straight in. Tom, can you skip two slides? Thanks. So the first case I'm going to talk about was handed down at the very end of last year, but just after our last update by a week. Um, I think it was Ed Folks, Paul Stagg, and Tom Jones in this from DECA. The facts were effectively it's a failure to remove case where there was a number of claimants, pretty horrific facts. They'd been abused either by their parents or parents' partners, and they brought claims against the respective local authorities that had been involved, alleging that they had assumed responsibility for protecting them, such as to give rise to a common law duty of care. Tom, do you want to give me the next slide? Now, the Supreme Court began by discussing how the common law interacts with statutory duties. So, obviously, for example, the Children's Act 1989, it doesn't breach of a statutory duty doesn't give rise to a tortious breach. You know, it's not the same thing. It doesn't give rise to a private law cause of action and to damages. There needs to be something else, and what the court said, as we've just indicated, there needs to be something else. That's unhelpful, but effectively there needs to be an assumption of responsibility in the same way that you'd expect if you were going to see a private individual for failing to protect. Next slide. So, what the claimants had to do in this case was establish a relevant assumption of responsibility. And that's, of course, because what they were asking the court to do was to impose liability on a defendant for failing to act for an omission, which, of course, runs against the general rule that one can't be liable in negligence in English law for a failure to act. Next slide, Tom. Um, Thanks. So the court was critical of the kind of vague use of this term assumption of responsibility. And what the court said is you need to sharpen the analysis and really ask what precisely is it the is the allegation that the defendant assumed responsibility to do with reasonable care. And in this case, what the claimants were asking the court to find was that the local authorities had assumed a duty to protect these children from abuse. I should say that what actually happened on the facts of these case is that the local authority had allegedly been informed numerous times of severely suspicious events. They had, in fact, taken legal advice and resolved to intervene to conduct an investigation to protect, as to whether or not these children needed to be taken into care. And inexplicably, it hadn't done that. Um, but looking at the facts of this case, there hadn't been any such assumption of responsibility in the view of the Supreme Court. Next slide, Tom. And what the court said is it's clear from paragraph 81 of N Pool that a local authority merely investigating a child's position, merely carrying out an investigation into a child's care, uh, doesn't amount to providing a service to that child. Rather, the purpose of the investigation is to allow the local authority whether or not to institute care proceedings to take the child into care. Um, and that would really, the reason why the local authority was doing that was for its own benefit. And similarly, when it took legal advice as to whether or not it should take these children into care, it wasn't taking that legal advice for the benefit of the child. It was taking advice for the benefit of the local authority, so it could know whether or not to exercise its statutory powers and duties. Thanks, Tom. Next slide. Um, So I should say before I finish talking about HXA, I think it's worth mentioning that the Supreme Court was quite critical of the Court of Appeal's comment in the case at the hearing below, the appeal below. Um, the suggestion by the Court of Appeal that this area of law was unsettled, the Supreme Court completely disagreed with that. Um, and it just to clarify what the court was saying, local authorities do these investigations. They take legal advice for the benefit of the local authority. If you want to establish an assumption, a private law assumption of responsibility, you need to look at it as if it was a private individual, so almost as if it was a foster care that had actually accepted these children and taken them into care, and then you're in a completely different factual situation. And of course, it's worth remembering that the court did not say that a local authority can never assume responsibility. It's just that you need to establish it in the same way as if you were dealing with a private defendant. Okay, so moving on then to this next case, Tyndall and Chief Constable. This is a case Ella Davis was led by Andrew Warnock in the Supreme Court recently. The facts were that a motorist was traveling along a road, hit some black ice, and came off the road. Now, fortunately, this motorist was only mildly shaken up. I think it was some chest trauma and so on. And he was able to then flag down oncoming vehicles on the road to warn them of the black ice, to tell them to slow down, that this was a danger that could potentially kill them. And whilst he was doing this, he was on the phone to the emergency services to call for the police and for medical care. Um, the police then arrived. They breathalyzed him. They sent him off in an ambulance to hospital and clear up the debris. Then they removed their police slow sign, um, called a gritter, and then drove off. And sadly, a few minutes later, the claimant's husband came along, lost traction on the black ice, and collided with an oncoming vehicle and was killed. Um, Next slide, Tom. So the court, echoing the discussion we've just heard in HXA, the court highlighted this fundamental distinction in the common law between acts and omissions. And another way of putting that is between making matters worse or harming somebody, or conversely, failing to confer a benefit or protect them from harm. And I think that's a really helpful way to look at it. Um, so many public authorities, police, fire, and so on, will have statutory duties and will have statutory powers to protect the public from harm. But even if they fail to exercise those powers and fail to carry out those duties, even if they do so carelessly, that isn't enough to find a private law duty of care and a corresponding duty to compensate. Next slide. Um, yeah, same point. So, fundamental distinction between making matters worse and failing to confer a benefit. Next slide. This is the summary of the principles that the Supreme Court made. Um, there is a difficulty in drawing this distinction sometimes, but the starting point is to remember that the a defendant generally owes no common law duty of care to undertake an activity which may result in a benefit to others. So it's only if actually in carrying out an activity, it's made matters worse, it's made someone worse off, that you can have liability. Next slide, Tom. Um, there was another very helpful discussion, this example of a parking a car and failing to apply the handbrake. Then the car rolls down a hill and causes damage to someone or something. If you sort of narrow the scope of your analysis, that is an omission. You omitted to put on the handbrake, and if you're going to apply that strict omission act rule, then you might come to the sort of counterintuitive conclusion that there was no liability here. But what the Supreme Court said is that you need to view the defendant's activity as a whole. So in this kind of example, you'd be looking at the entire activity of driving the car to this place and getting out of it without having put the handbrake on, rather than isolating that particular feature of the facts. A feature, something that you'll pick up from these cases is it all comes down to the facts and whether or not what how you analyze what actually happened. Next slide, Tom. Um, Court then talked about I think it's Nicholas McBride and Roderick Bagshaw's well-known book on tort. They had commented that there was a an interference principle, and they'd gone back and forth on this because they couldn't find any actual authority to support it. They had kind of found this interference principle by effectively analysing what the cases were really doing and showing. And the Supreme Court endorsed that interference principle. They said that although it doesn't feature in any binding authority, it follows in any case from first principles. It's simply a particular illustration or manifestation of the duty to take care not to make matters worse by creating a physical injury or a reasonably foreseeable risk of injury to a claimant. Um, and there's no reason in principle why conduct which creates this risk should not consist in acts which are reasonably foreseeably likely to have the effect of putting off or preventing someone else from taking steps to prevent the claimant from harm. So if you do something that foreseeably causes someone else to not to help or to cease helping a claimant, then that could well give rise to liability. Next slide, Tom. Unfortunately for the claimant in this case, there was a major factual difficulty. It wasn't clear on the claimant's pleaded case or in the evidence available from the transcript or on the to the emergency services that the police either knew or should have known that he had been warning or attempting to warn vehicles. And because of that factual gap in the claimant's case, they couldn't establish that in fact the police should have known that by attending and then leaving. Well, I suppose by attending they would cause him to stop warning other vehicles of the danger because of course he hadn't told them. They hadn't seen him doing that. And there was no way that they could have guessed that. You couldn't even infer that they could or should have known about that. And so, although the police won in this case, it's actually, in terms of the law, it's quite a dangerous case for the police and emergency services, and it could create quite a lot of future risk for them. Next slide, Tom. Okay, so this is the last case I'm going to talk about. It's again features two members of Chambers. I really didn't do this on purpose. It's just Andrew Warnock seems to be everywhere. It was Andrew Warnock and Jack Harding in this case. It was quite an interesting case about the illegality defense. Effectively, the unfortunate claimant in this matter had been diagnosed with schizophrenia in his 20s. A few years after that, he was arrested for grievous bodily harm. Effectively, he seems to have been under these delusions that various innocent members of the public were paedophiles. He attacked one of them that he wrongly believed to be a paedophile. The police arrested him, conducted a medical evaluation, and then released him on bail. A short time later, he sadly attacked and killed three individuals under the delusional belief that they too were paedophiles. He was tried for murder but found not guilty by reason of insanity because he just didn't understand the nature of his actions effectively. Um, he then brought the individual with schizophrenia who'd committed these killings, then brought a claim against the health authorities involved, or sorry, the health bodies involved, the police, and other defendants, the local authority, saying that they had been negligent. And there wasn't any finding yet. There isn't any finding yet, to my knowledge, about whether or not there had in fact been negligence. But the point was that the defendants had applied to strike out on the grounds that he'd brought a claim arising from his illegal conduct, effectively killing people, even if he'd been found insane when he did so. Next slide, Tom. And then the Court of Appeal. Lord Justice Underhill addressed the two broad headings in illegality cases. He said, first of all, there's the consistency principle, and secondly, there's the public confidence principle. On the inconsistency principle, it relates to the inconsistency between, on the one hand, treating the claimant's conduct as criminal, and on the other hand, allowing them to claim damages for the consequences of that conduct. Um, and on that point, they accepted, it was quite a simple analysis. They accepted the claimant's case that a verdict of not guilty by reason of insanity was an acquittal, and therefore there is no criminal conduct for the court to be concerned about that could be inconsistent with the civil law. Next slide, Tom. And then in terms of inconsistency with the civil law, the court also rejected the suggestion on the basis that the question of liability to one's victims for having killed them is a completely different question from the defendant, healthcare providers, and local authority, and so on, from their duty of care to him as someone who was a victim of insanity, effectively. Um, and in this latter case, he had been a victim of wrongdoing, at least on his pleaded case. Obviously, it hadn't been determined yet. Next slide, Tom. And then he moved on to the court moved on to the second issue, the public confidence principle. Effectively, what would the public think if they see a individual with schizophrenia who's killed three people completely unjustifiably, um, uh, and then saw him suing the local authority and so on in the public courts and receiving compensation for that loss, for for his sort of his present situation. Um, and for Lord Justice Underhill, that was the issue at the heart of this case, and I agree with that analysis. I think this is the really difficult point that makes illegality defences so difficult for the courts to handle. Next slide, Tom. Um, and the judge recognised, I think, as we all would, would have passed the Daily Mail test. This is going to stick in the throats of people who see that three innocent people have been killed, and yet the person who killed them will receive compensation for it. Um, and he cites this individual saying, talking about considered community values, and how we should be very slow to disregard those values. The law ought, so far as possible, to give effect to those community values. However, the judge said, I've come to the conclusion that although the first reaction is entirely understandable, the values of our society are not reflected by debarring a claimant from seeking compensation in this kind of case. It's necessary to go beyond that instinctive sort of knee-jerk instinctive recoil and consider what justice truly requires in a situation most humane and fair-minded people would recognize as far from straightforward. And I think it's a difficult case because you wouldn't expect yourself to agree with that conclusion, when you're told the initial facts. But I think one can see where the court is coming from. This is an individual who, through no fault of his own, is insane and is now in a terrible position. And if it is as a result of negligence, then arguably that is something that the law should compensate. Um, I have to call it there. Those are obviously much more complex, and there's a lot more to say about those cases. Fortunately, the barristers who are actually involved in them have all written very in-depth articles on our websites that you can see if you want to read more about any of those cases. In particular, they talk in those articles about what the courts didn't decide and what other angles remain open for future litigation. So I really recommend reading those. I've eaten up my third of your hour already, so I'll hand over to Ella now, and she can talk about clinical negligence.
Thanks, Conor. Before I do as well, just to add, there is an appeal to the Supreme Court next year in that Lewis Ranwell case, so something to look out for next year's roundup potentially. But moving to clinical negligence, as Conor said, there's three cases I'm planning to talk about today. One relates to interim payments, one on pleadings, and a roundup of this year's clinical negligence wouldn't be complete without me saying something about Paul. Next slide, please, Tom. So the first case relates to interim payments. This is the case of excess one. It involved a 10-year-old girl who had very severe disabilities. She had the highest severity grade dystonic cerebral palsy. And to give a bit more background, she was unable to mobilise independently. She had some visual impairments. She was largely tube fed. So as you can imagine, she was somebody who had quite complex accommodation needs. She sought an interim payment to fund the purchase of a new property, and it was a specific property. An offer had in fact been accepted on the property that had been found and that she believed was suitable for her long-term needs. She was seeking £2.15 million to buy it, but she'd already had substantial interim payments of £825,000. She had a fully pleaded schedule of loss, totaling about £19.2 million, subject to a 70% liability split in her favour. But still, it's on any view a substantial sum that was being sought. The application was adjourned in the end due to gaps in the evidence. It's a decision of Master Stevens, and she simply was not satisfied that the relevant threshold tests were passed. It wasn't disputed in this case that the claimant was in unsuitable as accommodation for her long-term needs. As I say, she was already at this point 10 years old, and her parents were having to carry her upstairs every night to bed. Her carers were accommodated on a different floor, the three-storey townhouse that the family were renting. So it wasn't going to be suitable for her long-term needs, and there was no dispute she was going to need suitable property in due course. And trial, I think, was either 1 or 2 years away from the date of the application. But at Eels stage 1, Master Stevens said was only able to value PSLA. She had difficulty with the evidence that the defendant had presented her. They had no care or accommodation expert evidence. Counsel in front of her was clearly in difficulty putting forward any precise figures in relation to most heads of loss, and resorted to having to make quite broad brush submissions about how the court should approach the figures in the schedule of loss. But the evidence from the claimant wasn't evidence the Master considered she could rely upon either. It did contain various errors. For example, the claim in relation to past care. The claimant did have a care expert who had valued the need for gratuitous care from over the course of the child's lifetime. But unfortunately, although the care expert had said that that would have to be subject to a set-off for the commercial care that had in fact been provided, that set-off didn't seem to have been carried out in the schedule of loss, or at least not fully. The Master wasn't able to work out the true value of past care. There was a claim for about £271,000 for therapies that the claimant had been to the United States for various therapies, and there wasn't the expert medical evidence in front of the Master for her to be satisfied that those therapies were reasonably required. There was witness evidence from litigation friends saying they'd been helpful, but that wasn't sufficient for the purposes of this application. The Master did consider accommodation costs at stage 1 of Eels, as is common, on the basis that it's a head of loss that's unlikely to be awarded by way of periodical payments. But here again, she had difficulties with the evidence and wasn't able to make a conservative estimate of the true value of the accommodation claim even. She didn't have, for example, the full range of opinion in relation to life expectancy. That, of course, is very relevant when you're trying to calculate the value of the reversionary interest. It turned out, it was apparent from looking at the claimant's accommodation report, that there were some errors on the figures. That much was conceded. There were issues about the way I think rental costs have been calculated. And I think the claimant conceded that in fact that the cost of the property was something closer to about 1.9 million, that the defendant on a very broad brush just said, oh, you won't get more than 1.25 million. And the Master said, well, that was effectively not good enough for her to reach a conservative estimate of the accommodation claim. She looked at stage 2 because it was conceded by the claimant that even on the claimant's valuation of the figures that should be brought into account at stage 1, there would need to be a top-up. The cost of the accommodation, the interim payment sought would exceed the figures that would be brought into account at stage 1. And here the Master looked at the threshold test of needing to be satisfied that there was a real need for accommodation now as opposed to after the trial, and that the amount of money required was reasonable. And she found that threshold was not met either. Um, no one, including the claimant's own accommodation expert, had suggested that the property wasn't suitable for her short to medium term needs. Plans were already afoot to adapt that rental property. The landlord had agreed to that, so it could be adapted. And although the master noted that it was regrettable that there would be the need to carry out those adaptations and then very shortly after reinstate the adaptations when the claimant moved to the ultimate property that would be purchased after trial, there'd be extended rental costs from being in that property for longer, and most significantly, the property that had been identified, the purchase of that might fall through. And she said all of that, she took into account all of that, but she still wasn't satisfied that they weighed against the fact that that real need for accommodation now had not been proved. Next slide, please, Tom. So she didn't have the evidence that she needed, and what she did was adjourn the application. I've only been able to touch very briefly on the details of that case. I think it's a judgment that is really worth reading if you have any sort of high value interim payment application, because I do think it's striking the level of detail that the master expected to have on what was initially a 30-minute listing in relation to all of the heads of loss. It was an early-ish stage in the litigation. The defendant hadn't been ordered yet to disclose their evidence or counter schedule, but the master effectively required the level of detail of a counter schedule from the defendant. The defendant had in fact applied to adjourn off the application to be dismissed on the basis that they didn't have, even in draft, their care or accommodation expert. Both experts had already been out and seen the claimant, the accommodation expert, 9 weeks before, but they applied to adjourn. And not very surprisingly, in my opinion, the master said no following the decision of Teller Elliott and Howling. But it again highlights the difficulty the defendants do have in responding to these applications and the need for evidence, because clearly they were in difficulty for counsel even in the background to work out the appropriate defendant figures. And lastly, the master said that if the claimant wished to proceed with the application, she invited the parties to provide a joint word schedule setting out their respective positions on each head of loss in a column each with a third column for the court. So another perhaps tip on the way that the master's bench might like to see these applications prepared. Next slide, please, Tom. And this is a further warning from the Master's Corridor in what they expect of parties. This is a case all about the way that one should plead defences in clinical negligence cases. It's the case of Mann and St George's University Hospital NHS Foundation Trust. Apologies for the typo there, it's not Mann v, it is Mann and St George's. But the pleadings, you don't really need to know the background to the case, but it's safe to say that at paragraph 13, the particulars of claim, that the claimant had alleged that she had told a nurse that she was in extreme pain. The defence, as they too often do, had responded to much of the factual background in a paragraph set out for you on your slide there, admitting paragraphs 3 to 35 insofar as they are consistent with the medical records, and stating that outside of that, the matters in those paragraphs fell outside of the knowledge and the claim of the defendant, and the claimant was required to prove them. Next slide, please. Slightly surprisingly, having pleaded the case that way, because as the master noted, paragraph 13 of the particulars of claim specifically pleaded something that was outside of the medical records. There was no recording of this complaint of pain to the nurse, and the claimant had taken the time to plead it in the particulars of claim. And it should therefore have been responded to in the defence, not simply by reference to the medical records, because they were silent on that. And having pleaded it in that way, the defendant then served a witness statement from a nurse, from the nurse in question, who said that if the claimant had been in pain, she would have recorded something different from that which was contained in the notes. But Master Sullivan held that was evidence that did not go to a matter that was properly an issue on the pleadings. So the defendant hadn't put in issue on the pleadings this complaint of pain. There was a further issue in relation to witness evidence in this case, in relation to a belitho witness, so a witness who was giving evidence about what would have happened but for the breach of duty. He was a surgeon who I think it was said would or might have operated on the claimant had that omission not taken place. But it was said to contain impermissible, and found by the master to contain impermissible opinion evidence. Where he'd gone astray is that his witness statement made observations as to the likely condition of the claimant at the time that she would have come to surgery. And the master said that was a matter for the experts. What the witness should have done, if necessary, where there was a dispute as to that condition, is to comment on a range of hypothetical scenarios. So, for example, say if the claimant had come in condition A, I would have performed procedure B. If she'd come in condition C, I would have performed procedure D. That would have been permissible factual evidence, but the line was crossed when the expert started to give evidence on matters that were in dispute as to the likely condition of the patient. Next slide, please. And it's a judgment that contains a very firm warning from the court about what they do and don't expect in relation to defences. I have to say, as somebody who pleads a lot of clinical negligence defences, I have a certain amount of sympathy. It's often difficult at the stage that they're being pleaded. Not all of the evidence is always available. There might be issues of cost in relation to what can be done in advance. There might be short timescales involved. But I think it's fair to say that most of those excuses are going to receive fairly short shrift in the courts now. And I've put here a few sort of practice tips that I think arise out of this case. The obvious one is speak to witnesses early. Now, I know that can be difficult to do for a range of reasons. Sometimes witnesses move on, they've gone to different trusts. You might have to work around clinical commitments. You might be working through various different people that you need to access that witness. But the master said, as I've set it out here for you, it seems to me it is not appropriate for an NHS trust in a clinical negligence case simply to say, well, we have not been able to ask. Again, there might be cases of truly untraceable witnesses, in which case you will have to say that that is the case. But it's clear that there is an expectation that appropriate factual evidence is taken from witnesses before defences are pleaded. The other option that it seems to me that could have been taken in this case is if something is inconsistent with the medical records, then say so. So as I say, here the claimant had pleaded something outside of the medical records. It said that the claimant reported pain. There was no record of that report of pain in the medical records. And I would suggest that a paragraph at least to that effect would have been important to say that the defendant doesn't accept that there's a report of pain because it's not there in the medical records. And the master made an important, but I think sometimes overlooked point, that putting a claimant to proof means just that. So you are requiring the claimant to lead evidence on the issue in question, but that doesn't entitle the defendant to lead evidence on it. If you want to prove a positive case, you have to plead a positive case. And the last practice point is that, of course, you need to be alert to the need to amend pleadings. This will sometimes involve withdrawing an admission. So again, that's an important reason to do it early. It's not good enough to simply serve a witness statement that contains evidence that's inconsistent with the defence and hope that nobody notices. If that arises and at the point where you're gathering your factual evidence, if you're acting for a defendant, you realise there's an issue, make an early application and make sure it addresses any need to withdraw an admission. Similarly, obviously, if you're acting for claimants, make sure you scrutinise these witness statements when you get them, check them against the pleadings. Are they dealing with matters that are properly an issue? So again, a clear warning from the Masters Corridor this year. And then next slide, please. Finally, I'm just going to talk a little bit about Paul. You could give whole webinars about Paul on its own, and indeed people have. We have one on our YouTube channel that was done by Laura Johnson KC, who was in the case. That will be a far more learned and detailed analysis than anything I can give you in the time available to me today, or indeed at all. So that's on our YouTube channel if you want, after hearing this, to go and look for a little bit more detail. But just in case anybody has been under a rock all year, I thought I would just touch on what this case decided. It's a case that involved three very tragic sets of facts. In essence, in every case, there had been a failure to diagnose and treat a medical condition, which later resulted in the shocking and tragic death of the deceased in front of their loved ones outside of a hospital setting. And undoubtedly, all of those incidents were very traumatic. But all of the claims were dismissed by the Court of Appeal, who considered themselves bound to follow Taylor A. Novo, and being bound to follow it, considered that led inevitably to the dismissal of the claims. Novo was a case where a woman had some racking boards fall on her head. She sustained injury. She was treated in hospital. And then I think it was about a week later, died from a pulmonary embolism in front of her daughter very suddenly. It's a case that had been understood differently by all of the judges below, and the Supreme Court said they'd all misunderstood it in effect and took the opportunity to explain what it meant. They said it was a case that was correctly decided because the claimant was not present at the scene of the accident, and what she witnessed was not an accident. So the accident was the racking boards falling on her mother's head. What she witnessed was the death by pulmonary embolism some days later. It was, the Supreme Court said, authority for the proposition that no claim can be brought in respect of psychiatric injury caused by a separate event removed in time from the accident. Next slide, please. But what it didn't decide was anything about the distance in time between the event which caused psychiatric injury and the original negligence. Obviously, in common cases of road traffic accident, those will be almost simultaneous, so the negligence and the event causing injury. But there are cases, the court gave an example of a building case where somebody has negligently erected a building and masonry later falls on a child in front of their parent. The negligence might happen very many years before that accident. So that's not a barrier to claims. In fact, there's no authority to the effect that the right to recover damages for witnessing a person's death or injury in an accident depended on closeness in space and time to the defendant's breach of duty. Next slide, please. But that, unfortunately, was not sufficient for these claims, because what the Supreme Court has done, this is a decision really that it is a root and branch overhaul of the law in relation to secondary victims. And what they've said now is that such claims are limited to claims arising out of an accident. That means that realistically, it will be very unlikely in future that they will occur in a healthcare setting, and that events of clinical negligence will give rise to claims by secondary victims. The court did leave open the example of what happens if a doctor injects the wrong drug into a patient and they suffer an immediate acute reaction. Might that be an accident? I don't know. There may well be further, I'm sure there will be further litigation to come, if not in the healthcare setting, then outside, about the meaning of an accident. But the vast majority of cases where there is clinical negligence and a patient perhaps deteriorates in their pre-existing disease or dies over a number of days, those are not going to constitute an accident and there won't be a claim. And the court said that a person could not reasonably be expected to be shielded by the medical profession from the exposure to the traumatic experience of witnessing the death or manifestation of disease in their relative. The person whom doctors should reasonably have in contemplation when directing their minds to a patient's care do not include members of the patient's family who might be psychologically affected by witnessing the effects of a disease which the doctor should have diagnosed and treated. In essence, they say there's no duty of care because there's no proximity between the doctor and the family members in these cases. Next slide, please. So that's really what Paul means for clinical negligence cases, but obviously I'm aware we've got attending today lots of personal injury practitioners as well, and I just thought it's worth flagging that this case is relevant to you too, because as I said, it's a full overhaul of the law in this area, and the court took the opportunity to clarify that liability does not depend on the claimant experiencing a sudden shock. That was a sort of hangover from a misunderstanding of the medical science behind psychiatric injury from some of these cases that are now very old, nor does it depend on witnessing a horrifying event. Obviously, if an event is not objectively horrifying, there might be some questions of reasonable foreseeability. A claimant also has to prove causation, that they did in fact suffer psychiatric injury as a result of what they've witnessed. But if those tests of foreseeability and causation are met, the court said you don't need to superimpose a test about what is and isn't a horrifying event, because that invites lots of invidious comparisons between these very traumatic cases as to who has and hasn't experienced something which is horrifying, and that's not the role of the courts. They said that in developing those additional requirements, the law had taken an unfortunate wrong turn, which these appeals enable us to correct. So that's just a flavour of what happened this year. I'm sorry, I forgot to include a slide, but I just thought I'd mention what to look out for next year in 2025. In December of 2023, the Supreme Court gave permission for a direct appeal in the case of CCC, quantum decision of Mr. Justice Ritchie in a birth injury case. So that, I think, is going to be a very interesting thing to look out for. One assumes the hearing will take place somewhere next year. But with that, I will hand over to Tom. Tom, you're still on mute.
Apologies, thank you, Ella. Yes, mine's going to be a bit of a whistle-stop tour through some travel cases this year. I've got 5 cases and a little bit of legal framework to get through. If I speak a little bit quickly, I do apologise, but I think with the exception of the Tidyman case, although I'm not even sure that might not even be an exception, but with the possible exception of that case, I think there are articles on our website about all of these cases and indeed the legal framework point that I've got at the bottom. So I've got there the case of Sherman, case of Team 4, there are actually, it's Nichols and several other cases and Mapfree, but all heard together. The Tidyman case, which is County Court decision, Miller and Irwin Mitchell, which is really a professional negligence case, but it touches on some elements that might be relevant to travel practitioners, and then a little bit about how the legal framework is changing in 2024 in relation to cross-border litigation. So, starting with the first case, Sherman and Reader Offers Limited. Well, no conversation about travel law in 2024 could possibly be complete without talking about this case. For anyone who doesn't know it, this in a nutshell, and I'll try and be as neutral as possible because I was in the case, is the story of a couple who booked a cruise with the defendant tour operator. And the cruise was, well, pick your preposition, in, around, through, adjacent to, approximate to, touching upon, flirting with the Northwest Passage. So cruise relating in some prepositional way with the Northwest Passage. Unfortunately, the proposed itinerary, the originally proposed itinerary, couldn't be performed due to unusual, I'll come back to that adjective in a minute, patterns of sea ice that were present in the Northwest Passage that year. So, again, pick your, this time adverb, minimally, slightly, markedly, entirely different cruise was provided by the tour operator. And the claimants sued on a number of bases, including unlawful imprisonment. They said they were falsely detained on board this cruise ship. They couldn't get off, that went to all these locations that they didn't want to go to. They pleaded deceit, pleaded all sorts of things. But ultimately, they were successful after they were unsuccessful to start with in the county court, successful on appeal to the High Court, and successful again on further appeal to the Court of Appeal. And they succeeded in arguments on regulations 12, 14 and 15 of the 1992 package travel regulations. So the old regulations, practitioners will be much more familiar in more recent years of dealing with the 2018 regulations. But there are some elements of the judgment, even though it was dealing with the 1992 regulations, which are highly relevant even when we're looking at the 2018 version. Starting with what was decided and a bit of good news for the tour operator side of things, the defendant side of things, there was a small win for the defendant in the Court of Appeal, and that was the overturning of a rather odd decision of the High Court, Mrs. Justice Collins Rice, on the interrelationship between the regulations and English contract law. So rather oddly, Mrs. Justice Collins Rice in the High Court had decided that effectively, until a tour operator had complied with the provisions of the regulations which required certain details to be contained in the contract, brochure details, itineraries, things like that, until there had been compliance by the organizer, tour operator, with the requirements of the regulations for what you put in the contract, then the contract could not be considered binding. That was her finding. No binding contract until compliance with the regulations. And it seems that that was probably on her part a misunderstanding of the word condition in the regulations, because it was set out in the regulations that it was a condition of the contract that you provided this information to the customer. But of course, condition was being used in its old-fashioned English contract law sense to mean a very important term of the contract, which could give rise to a right of repudiation in the event that there was a breach of it, rather than meaning it was some kind of condition precedent for the existence of a contract in the first place, and that the regulations were in fact affecting normal English rules of contract on when a contract is not formed. So formation of a contract, offer, acceptance, etc. So she got that wrong. Mrs. Justice Collins Rice got that wrong, and the Court of Appeal corrected that, and they said no, the regulations are not rewriting English contract law. You still look at whether there is the offer, the acceptance, the intention to form legal relations, etc., and you do it in the normal English contract law way. And if you form a contract that then there is a breach of later down the line, then you deal with that breach. But it's not that you've created some kind of non-binding contract. So that was the good part for the defendant in the Court of Appeal. But the bad part is really the rest of it. But a lot of this case rested really on the defendant's own expressed terms and conditions in that case. And the terms and conditions of the defendant in that particular case specified a moment for formation of contract, which was the issuing of an invoice. And as a matter of fact, in that case, that issuing of an invoice didn't occur until a relevant date in late January of that year, which meant that the contract wasn't formed until that date, late in January, which meant that when it was formed, it included all of the bits and pieces about the itinerary that the defendant had been hoping were not incorporated within the contract. And the Court of Appeal found they were incorporated within the contract because the contract was not formed until the invoice was issued as a function of the defendant's own terms and conditions. So really, the result for the defendant turned very much on its own expressed terms and conditions. And again, with the defendant's perspective on it, that's relatively promising news for an operator, because it means that they have control of formation of contract by what they write in their terms and conditions. As I say, the High Court determination that there was a non-binding pre-contractual non-contract because of the effect of the regulations was for the birds. What else happened in this case? Well, the Court of Appeal also approved, albeit obiter, the recorder's dismissal of the old flicker of hope test, which defendant operators had been wont to use since the early case of Lambert under the older regulations. That was essentially an argument that while there was even a flicker of possibility that a tour might be able to go ahead, then an operator didn't have to alter it and didn't have to inform their customers that there had been changes to it, or indeed that it had been cancelled. Flicker of hope test is now no more. I will talk a little bit more about that when I talk about the Team 4 case, which is going to come up as my second case. They also, the Court of Appeal in the Sherman case, read Regulation 12 in the old regulations as requiring a tour operator, when making a major change to an essential term of the contract, to inform the customer of their right to cancel that arose under Regulation 12 of the old regulations. They had to both make the change and inform the customer of the right to cancel arising out of that change. That's not actually obvious on the face of the legislation. And finally, in my view, they incorrectly divorced unforeseeability from predictability. So essentially, they came to the defendant was trying to argue that they had a defence under the old Regulation 15, that this was all due to unforeseeable and extraordinary circumstances outside of their control, and that they weren't liable accordingly. And that was rejected in the High Court, and the Court of Appeal affirmed it. But the logic of it, in my view, is wrong because they were saying essentially it was well known that sea ice conditions in the Arctic are inherently unpredictable. And yes, although there had been 10 years or so where these particular ice conditions had not occurred, it was known as a possibility that there was a lot of unpredictability and sea ice conditions could change rapidly and could be very different one year from another. And so, because in a sense, there was a possibility of sea ice conditions being such as to prevent the cruise, that meant that it was foreseeable and the defendant couldn't rely on the unforeseeability defense. But the implication of that, of course, is that you're essentially saying that anything which can be conceived of as happening by the human brain is foreseeable, because every hurricane is, in a sense, foreseeable because it might happen, and you know that it's inherently risky to cross the Atlantic at any time because there might be a hurricane or whatever it might be. Any volcanic eruption, it might happen. Every sudden onset of war, etc. And so effectively, the Court of Appeal appear to be pushing that unforeseeability test really to its limits, to something which cannot even be conceived of as a possibility of occurring. And in my view, if that's the direction they're going in, that's wrong. I'm going to move on because I'm short of time. I want to talk very briefly about the Team 4 case, and then I'll whistle through the others. So the Team 4 case was a cancelled school ski trip to Austria during the height of the COVID-19 pandemic. It's a decision of Her Honour Judge Beach in the County Court at Preston. So it's not binding authority, but it does provide a useful summary of arguments frequently deployed in these types of cases. There are cases which rely on Regulation 12.7 of the new regulations, the 2018 package travel regulations, essentially in the event of extraordinary circumstances occurring at the place of destination of the holiday and which significantly affect performance of the package, then a customer can cancel and get a full refund. But the legislation is messy and it's given rise to all sorts of bits of litigation because of the COVID-19 pandemic and all of these trips which were cancelled in 2020, 21, 22, and lots of interesting things occurring in lots of these cases. And in Team 4 this year, Her Honour Judge Beach drew quite a few threads together and provided some helpful guidance, at least on how she saw some of the case law in this area. First, she talked about the idea that school trips might be argued to be general agreements and therefore not packages. She didn't like that idea. She said that general agreement clearly meant business travel and school trips were not business travel, although she slightly kept her powder dry in relation to private schools rather than local authority run schools. She looked at the temporal question of Regulation 12.7. So the extraordinary circumstances have to significantly affect in the present tense performance of the package. But of course, that makes no sense because you're always looking somewhat into the future. But she agreed with an earlier case, the Bryn Mawr case, forgive my Welsh pronunciation if that's not right, that you're always looking somewhat into the future when you're thinking about whether you're cancelling because of extraordinary circumstances. And she formulated the test as whether a reasonably intelligent person would look at the circumstances and say, yeah, that's going to affect my holiday at the time at which the cancellation is made. So it's not the present tense is used not as a strictly contemporaneous present, but as a reasonable apprehension by a reasonably intelligent person of what the future looks like. She looked at the geographic issue, which is that the extraordinary circumstances have to be present at the destination. She looked a little bit at EU law on this, and she decided that effectively it's a global pandemic. If it's present at the destination and it's present at the place of departure, that counts, even if actually it's more present at the place of departure, and it's more that's causing the problems than the destination. It's a global pandemic. It has to be looked at in its wider context. And the test is just whether it's present at the place of destination. I'm going to jump through now because I'm out of time. The MAPFRE cases were all about Spanish penalty interest, whether that was a procedural or substantive part of Spanish law. If it was procedural, then was there a judicial discretion to award it anyway? In the event the courts found that it was a substantive part of Spanish law, and that's been plaguing various bits of county court and high court litigation for quite a while because there were conflicting authorities about this, one of which Conor was in a while back. But this now looks to have been finally determined now by the Court of Appeal. Spanish penalty interest is a matter of substantive Spanish law. Tidyman, this is a holiday sickness case following Griffiths being decided in the Supreme Court last year. I would just invite those listening to go and read it if you work in the holiday sickness area, because it's quite a good exploration of what you need to show in holiday sickness cases. It explores Griffiths, it explores Wood, and looks at quantitative and qualitative evidence. And very importantly, it talks about experts, and the experts unusually in that case were called to give oral evidence and were cross-examined, and some helpful defendant comments are created by that judgment in respect of a very commonly used claimant expert microbiologist. So it's worth both claimant and defendant practitioners reading that case to see how the microbiology evidence is analysed in that case. Miller, this was another Andrew Warnock and this time Andrew Spencer case. It was a professional negligence case, really, but the point for travel practitioners is about whether there's a duty of care owed by solicitors to their clients as to whether they have to ensure that the other side, in this case a tour operator which was in severe insolvency difficulty, notified their insurer and thereby effectively complied with their policy of insurance such that the claim was going to be covered by insurance on the defendant's side. And the court essentially decided there was no duty of care on the claimant solicitors to ensure that the defendant would notify their insurance even when they're in some kind of insolvency difficulty. And then the final thing that I just wanted to talk about was how the legislative landscape has changed in 2024. Two important things. The Hague Convention has now been ratified by the UK in June 2024. It's also been ratified by the EU. So we now have a binding international treaty between us and the EU states, excluding Denmark, of course, who are always very awkward when it comes to civil judicial cooperation. But we've got the EU and the UK and Uruguay, interestingly, as now ratified members of the Hague Convention 2019. So what does that do? Well, it now, for the first time, includes personal injury within its scope, which was previously excluded by the former iteration of the Hague Convention on Enforcement of Judgment. So personal injury is in, but there are limitations on it. So, and importantly, Article 5(1)(j) says that if it's a claim for tort, for personal injury, the act or omission that you are seeking to enforce in other jurisdictions has to have occurred in the origin state. So the origin state being the UK, effectively, the place where you get your judgment and you want to enforce it elsewhere. It only applies for personal injuries arising out of torts which took place in the UK. So not great for probably 80-90% of travel practice where this is all about accidents abroad, but it has some relevance, of course, particularly in the road traffic accident context, where you're suing a foreign defendant for an accident that occurred in the UK on roads, for instance, if you had a driver from the Netherlands who caused an accident and you're trying to sue them in England, you get through the jurisdictional gateways, but you end up with a judgment that you're then trying to enforce in the Netherlands. Now you can do that via the Hague Convention. So it's useful in some ways, but it's a big exclusion that the act or omission has to be in the origin state, i.e. the UK. Carriage of passengers is also excluded, and there is a public policy basis for refusal. So some of the awkward jurisdictions who don't like the way in which English courts do CFAs, or who don't like the way in which English courts have huge costs in relation to litigation of this type, they might say, well, we will refuse to enforce your judgment for public policy reasons. So Hague 2019 is in no way a substitution or even close to a substitution for Lugano that we were denied access to, or indeed Brussels, which we left automatically by virtue of Brexit. And then the last thing I've got there mentioning is the after the sunset on retained EU law on the 31st of December 2023. So what's happened in 2024? Well, not a huge amount, because actually by the time that act got royal assent, it had been so watered down by amendments in the Commons and the Lords that effectively it didn't do very much. It got rid of the principle of supremacy of EU law. It changed the mechanism by which decisions of the CJEU would be considered in the English courts. But what it didn't do, which everyone was worried that it was about to do, was cause chaos in the UK statute book by immediately deleting a whole load of legislation that practitioners in this area have been long used to relying on. So it didn't do that mass deletion that everyone was fearing that it might. It didn't cause that chaos, but it has got rid of the principle of supremacy of EU law. It's yet to be seen how much of an effect it's had. I've not found any cases in my trawl through that have really been decided differently or have gone a different way because of the effect of the 2023 Act. So that brings me to the end of my talk, and we're at 1 o'clock. So I think all of us took about 20 minutes, which meant that we've slightly limited time for questions. So I apologise for my part.
Oh, likewise. Should we quickly deal with the pre-submitted questions that we had at least?
Yeah.
One of them was a question that would probably have been for me. Are there any developments this year in vicarious liability and non-delegable duties in healthcare? I'm actually not going to answer it. I'm going to duck it by saying that our colleague Susanna Bennett has written a book that's out this year on exactly that topic. So if you want to look at that, I recommend you go dig up Susanna's book. And we were asked about the latest in failure to remove cases. Obviously, Conor's talked about HXA. There were 2 cases this year in relation to strikeout. One of them was SZR and Blackburn. The other was EXE and Bradford. Both of those I've written articles on that are on our website, so you can go and look at those as well. So I'm sorry that we're just signposting rather than answering those questions given the time. We were also asked about any questions that we disagreed with this year, which is a really interesting question. But I've come over all deferential this year, and I don't particularly have any, apart obviously from when judges are found against me. I can't remember if either of you had any other questions that you wanted to deal with.
I don't think I think that's everything. I think it was just Tom that disagreed with one of the judgments, but I agreed with mine.
Yes, it was I just disagreed with the passing of unforeseeability in the Court of Appeal judgment in Sherman, which I think is a slightly dangerous passing, pushing unforeseeability right to the limits of human conception, which I think is probably too far. And then another question about Regulation 12.7 in the Package Travel Regulations 2018. I touched upon that when I was talking about the Team 4 judgment. It is a really messy area of litigation at the moment, and there's lots and lots of county court decisions about the meaning of Regulation 12.7, which is a badly drafted piece of legislation. My own views on it are published on the website. I've written a couple of articles about what I think about causation, etc. in Regulation 12.7 context. But it's a really interesting area of law, and at the moment there are no higher court authorities about it. So, though I think Connor's taking one on appeal
Just to
sometime.
the circuit judge, not to the High Court. But yeah, I agree. It needs a High Court authority. Okay, well, unless there's anything else, thank you very much for giving up your time over your lunch to listen to us tell you about the latest cases. I think, as we all say, if you want more detail, I think we have more detail on all of those cases on our website, often from the counsel involved in the cases. So do check that out. Otherwise, have a very Merry Christmas and hopefully see you this time next year, if not before.